If you are a U.S. citizen and you're wondering if your child can derive citizenship from you, well, this is the video for you. We are going to talk about when a U.S. citizen parent can give citizenship to their child that is born outside of the U.S. but does not qualify for a CRBA, a consular report of birth abroad. I am U.S. immigration attorney Lilian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. The first thing you need to know is that there is two different processes for getting children that are outside of the U.S., born outside of the U.S., citizenship when they do not qualify for citizenship at birth. One is through a form called N-600 and the other is through a form called an N-600K. There is a significant difference between these two forms and when you use each of them. The N-600K is used when the child lives outside of the U.S. They have never been in the U.S. They do not have permanent residency in the U.S. They are physically residing outside of the U.S. But even though they're physically residing outside of the U.S., they qualify for citizenship. An N-600 is a form that you use to show proof of your citizenship. So when you file an N-600, the child resides in the U.S. and is a permanent resident in the U.S. So that's when you would use an N-600. The N-600 gives you a certificate of citizenship, while an N-600K is more of a naturalization for that child. So it's not the same thing as an N-600. An N-600K is more of naturalization. It's similar to an N-400, while an N-600 gives you a certificate similar to a CRBA. Now, if your child lives outside of the U.S., but you live in the U.S., the N-600K is not an option for you, because in order for you to get an N-600K for your child must be in your legal and physical custody. And the only way to do that is for you to physically live with your child in their country. So that is why it's important to know the difference between an N-600 and N-600K and when you would use one over the other. An N-600 results in a certificate of citizenship for children born outside of the U.S. but are residing permanently in the U.S. And when I say residing permanently, I don't mean that they just live permanently in the U.S. I mean that they have permanent residency, a green card in the U.S. So you would use an N-600 to show that that child is already a U.S. citizen. That's why it's a certificate of citizenship, not a certificate of naturalization. A certificate of citizenship says that the child is already a citizen and you are just giving them proof of their citizenship. Now, let's talk about how a child can be automatically a citizen and can apply for an N-600. In order to qualify for an N-600, the child must have at least one U.S. citizen parent. That parent can be a citizen by birth or a citizen by naturalization, does not matter. They just need to be a U.S. citizen in this requirement. The child must be under the age of 18 when they meet all these requirements. They do not have to file the N-600 while they're under the age of 18. They just have to meet the requirements while they're under the age of 18. Again, when you are meeting these requirements, you are automatically becoming a citizen the day that you meet every single one of the requirements. The next thing you need to show is that the child is a permanent resident of the United States, and finally, that the child is living in the legal and physical custody of the U.S. citizen parent. Like I said before, when it comes to these requirements, you just have to make sure that the child meets all of them before they turn 18. And then once they meet all those requirements, the child is automatically a US citizen. So when you file an N-600, you are just getting proof of that citizenship. You are not giving them citizenship at that point. You already gave them citizenship. You are not getting proof of their citizenship. I am going to break down one of the requirements on here because it really gets people stuck when it comes to the N-600. And you need to know what it is ahead of time so that you can plan in advance on how to handle the legal custody part of things. If you are in a situation where you want your child to physically be in the US with you, so you're filing an I-130, you're doing your DS-260, they got their visa, now they're in the US, and you are trying to make sure that you meet every single requirement so that they can get their N-600, so that they can derive citizenship from you. Let's talk about the one thing that can really derail the whole process. The one thing that can really derail the N-600 process is the legal and physical custody requirement, especially when the parents are not married to each other and they do not reside in the same home. That is going to mess up the legal and physical custody requirement. So the US citizen parent has to show that that child is living with them in their home. They have to show that they have legal custody, either shared with the other parent or sole legal custody over that child. That is easier to do when you live in the same home with the other parent, you're married to the other parent, or the other parent is not physically in the US. Right? They're outside of the US and they let the child come into the US to live with you. That shows the legal custody because you are the parent that they are living with and that has legal say over their lives, okay, and their actions. So that is why in those three situations, again, you're living with the other parents, you're married to the other parent, or the other parent is not physically in the US. In those situations, legal custody is kind of a given. Physical custody is also kind of a given because you are living in the same household with the other parent, or the child is living with you because the other parent does not live in the US, right? So that's when those are given. However, there are situations where both parents are in the US, but they're not living together, they're not married to each other, they do not have a relationship anymore. And the question becomes, who does the child live with? And sometimes people will tell me, well, our custody agreement says that we both share 50-50 custody and, blah, 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 blah. Great. But who does the child live with? If I check the child's school records, who does it say they live with? If I check their medical records, who does it say they live with? Right? That's where your custody agreement does not decide what the physical presence is. It's the actual reality of the physical presence that matters. So if, let's say, you have 50-50 custody, but you live in two separate states, it is going to be hard to convince a USCIS officer that you actually have 50-50 custody because the child has to be in a specific school. They can't be switching schools every week, right? So just because you have your child for the summer does not mean that they live in your physical custody. I'm sorry, right? So it is so important to know this ahead of time that you are able to make arrangements to make sure that you meet that physical custody requirement. I have had to have this conversation with parents and explain to them that physical custody is a must. And they have had to either have the child move in with them full time because they did not understand how the whole, derive citizenship works, how the N-600 works. But once I explained it to them, they're like, oh, so I just have to have my child live with me full time? And, based on what the custody agreement says, I'm like, yes, right? Yes, that's what you have to do. Your child has to live in your physical and legal custody when it comes to the N-600. So Once you meet all of those requirements, now your child automatically becomes a US citizen, and then you file an N-600 to actually have proof of their citizenship. You are not filing an N-600 to prove that they're a US citizen. You're filing an N-600 to get proof of their citizenship. So it's like a US citizen born in the US getting a copy of their birth certificate. It's just the birth certificate shows they were born in the US, therefore they're a US citizen, right? So it's similar to that in filing an N-600. The fact that they're getting the birth certificate the birth certificate is not the thing that makes them a US citizen. Is the actual birth in the US that makes them a US citizen. Just like for an N-600, getting that certificate of citizenship is not the thing that makes the child a US citizen. The fact that they meet all the requirements for an N-600, that is what makes them a US citizen. The crazy part with the N-600 that people don't really think about is that you don't have to apply for it. There's no requirement to file for it while you're under the age of 18. So I've seen people that are in removal proceedings that didn't know that they were already a US citizen, right? They were put in deportation proceedings, and their lawyer was able to look through their history, their family's history, and figure out, oh, wait, you are already a US citizen. And they were able to get proof of the citizenship, get them their N-600, and get that case closed. So now, because they were already a US citizen, they were not deportable. So that's another reason that it's so important to make sure that you are following the right process to get your child that proof of citizenship. Now, let's talk about the N-600K, because that is a whole different requirements and beast on its own. Now, like I said before, the N-600K requires the child to live outside of the US in your legal and physical custody. So the US citizen parent is living with that child. So if you're the US citizen parent and you have no intentions of moving back and living with the child, then go ahead and file an I-130 and go through that process and eventually get them the N-600, right? But if you are the US citizen and you're living outside of the US, right? You have a job outside of the US, you're building a life outside of the US as a US citizen, then let's see if you meet the requirements of an N-600K and are able to give your child citizenship even though they are residing outside of the US with you. Remember, the N-600K is for people that have children outside of the US. Either the child did not meet the requirements for the CRBA, or the child was born before you became a US citizen. In those two situations, you want to look at whether they qualify for CRBA, and if they don't, then the N-600K may be the best option because, again, the CRBA and the N-600K does not require the US citizen parent to physically reside in the US in order to get that benefit for their child, while an N-600 does because, again, the child has to be in your legal and physical custody. The first requirement of the N-600K, just like the N-600, is that the parent, at least one parent, is a US citizen, okay? The next requirement is the US citizen parent was physically present in the US for a total of 5 years. 2 of those years has to be after they were the age of 14. Or, unique thing with the N-600K, or a US citizen grandparent meets this physical presence requirement. So with the N-600K, there's a unique thing where you can either use the physical presence of the US citizen parent or US citizen grandparents. So the grandparents either has to have 5 years of physical presence to make up the fact that the US citizen parent does not have the 5 years required. The third requirement here is that the child must be under the age of 18 when you file this N-600K. It is one of the big differences between the N-600 and the N-600K is that the N-600, you just have to meet the requirements before the child turns 18. They can apply for it at any time, but they have to meet the requirements before they turn 18. Whereas the N-600K, they have to apply for it and get it before they turn 18. So that is a huge difference. So if you're already over the age of 18, you may need to do something else, okay? I'll be talking about what else you can do in an upcoming video. The fourth requirement is that the child must reside outside of the U.S. in the legal and physical custody of their U.S. citizen parent. Again, the legal and physical custody part of things is similar to the N-600. So the same conversation about who does the child actually live with will also apply to this. So just keep that in mind as you are thinking about the legal and physical custody aspect of the N-600 and the N-600K. And then the final requirement is that the child is temporarily and lawfully in the U.S. and maintaining lawful immigration status while they're physically in the U.S. Why does that matter? Because the N-600K is a USCIS application. It is not an embassy application, which means there's going to be an interview at the USCIS office in the US, and that child has to lawfully enter the US and maintain lawful status in the US while that N-600K is being processed. So they have to come into the US lawfully, go to their N-600K interview. You heard me? Go to their N-600K interview and then wait for that N-600K to be approved. And they have to maintain legal status the whole time that they are physically in the US. Remember, the child does not have to reside in the US. They're just here for their interview. And once they get their N-600K approved and get their certificate of naturalization, they can apply for their passport and get out of the US, right? So it is very important that you know these things. There are special provisions for parents that are U.S. citizens that are in the military. So they get special treatment when it comes to the legal custody, the physical custody, and of course the physical presence in the U.S. Okay. Additionally, if the U.S. citizen parent that the child is deriving citizenship from has passed away, their grandparents or their guardian can do the N-600K application for them. Remember, this child is under 18, so they must have a guardian help them with these applications. Also, if that parent is deceased, this N-600K application must be filed within 5 years of that parent passing away. Okay, it is so important. There is a time deadline for this. Okay, if the parents passed away 6 years ago, the N-600K is no longer an option. If they passed away 2 years ago, the N-600K is still an option for the child. So it's really important that if you are the grandparent, the other parent, the guardian of a child, that their parent was a U.S. citizen, met all the requirements that we just talked about, but they have passed away, that you are taking the steps as soon as possible to get the N-600K filed and processed for the child so that they can get their citizenship. It is really important that as you are deciding between the N-600 and the N-600K, or going through just getting the child citizenship, that you are following the right process, that you are gathering documentation. Again, that legal and physical custody part of it is so huge because you really have to show that that child lived with that parent. It doesn't mean that they live with the parent the whole time that they are in the U.S., but at some point, while in the U.S., while they had their green card, while that parent is a U.S. citizen, they lived with that child in the U.S. or outside of the U.S., but they have to meet all those requirements. So that is really important, and it's also important that you have the documentation to back it up, right? So make sure you're following the steps. Make sure you're evaluating whether this child can get citizenship through their parents, and if they're outside of the U.S. and you're outside of the U.S. with them, whether they can get it through the N-600K without ever having to reside in the U.S. I hope this video has been helpful if you are considering between an N-600 and N-600K and don't understand the difference. Hopefully, I have made the difference clear for you in this video. If you are trying to decide, or you have decided that an N-600 or an N-600K is the right way to go, and you want help with that process, or you want help deciding what to do next, feel free to schedule a strategy session with me. That is the whole point of it. It's a free 15-minute session where we talk about your situation, figure out what you qualify for, and how we can help you through the process. You can do that by going to my website, lilylegal.com, and clicking on Contact Us, where you can pick a date and time that works best for you for us to chat about your case.